Hello, everyone. As you trickle in, we're going to give it another 30 or so seconds here, get everybody in here, and then we will kick it off. All right. Welcome, everyone, to this office hours on all the legal aspects of buying a business. My name is Will Smith. I'm the host of the podcast Acquiring Minds. Attorneys James David Williams and Bill Barlow are going to host the session, their third office hours with Acquiring Minds. These have been very popular sessions, very high value for searchers and sponsors like you, if you're hearing me talk right now, navigating the commonly very tricky legal terrain of buying businesses. James David and Bill are partners in Barlow and Williams, the name of their firm. It's a firm that they specialize in small business acquisitions. So this is their wheelhouse. They see tons of deals. They're at the front lines of the market. And their focus really is searcher and sponsor deals, getting those deals done for you while, of course, protecting your downside. And they also represent sellers. So you're getting expertise here from both sides of these transactions. I'm going to hand it over to them in just a sec, but a couple of usual housekeeping. The way we run these is that Bill and James David have brought a presentation. It's about 20 minutes long. Today's is common legal diligence issues and how to handle them. You all probably know that. That's how we were marketing this session. But we'll do that for the first 20 minutes, and then we leave a lot of time for questions. Questions about the presentation or not, just other legal questions related to buying a business. That's why we call these office hours. It's really to come get questions answered from legal experts. So to do that, to ask a question, we use the Q&A function of Zoom. You should see where is mine? There it is, the Q&A button at the bottom of your Zoom screen or in your Zoom app. So chat is turned off. I can chat to you all. We have broadcast chat turned on, but your chat function won't work. So questions go to the Q&A button. The session is being recorded. You'll receive a link to that by email in the coming days. And finally, in that chat, I am going to put here links to all the relevant material, James, David, and Bill's socials, their website, and the 2 office hours that they did back in June and July, the do's and don'ts of the LOI, that was June, and overcoming common deal sticking points was last month, July. There, it should be in everyone's chat, all the links to all that good stuff. And that's it for housekeeping. Bill, James, David, over to you guys.
All right. Thanks so much, Will, for that introduction. Super happy to be back. These are always a lot of fun. So just giving you a little bit of an overview of the topics that we're going to cover today. These are all topics that have come up in our transactions when we're dealing with searchers. So, you know, with each of these, we'll have stories to tell. We'll talk about what to do about it. And our goal here is usually, just to kind of paint the picture for you, usually what happens is once you sign an LOI, your attorney will send over a list of legal diligence questions. The seller is going to fill it out. And then based on that, based on other discussions that you've had, it's not uncommon for one of these issues to arise. Sometimes you already know that this is going to be an issue, you know, before you're doing the LOI, you're addressing at that stage. And that's actually great because you don't want something to come out of nowhere. But a lot of times you're in the middle of the process and you're trying to figure out what are you going to do with this particular situation. And so our goal here is, first of all, inform you what the issues are. And then secondly, if this does become an issue, what are the tools in your toolbox that you'll commonly see used in order to find some way to resolve it? Right. Go to the first one.
All right, so the first question that will come up in diligence and can be a major issue, and you'd think this wouldn't be an issue, but you'd be surprised, is the question is who owns the seller, right? And what that really means is who needs to approve the transaction on the sell side, right? Even there can be corporate structures where a seller who has a 2% ownership stake still has to approve the deal. We had one transaction where it needed to be we were buy side, our client needed to maintain the entity for various reasons. So it needed to be a stock purchase. But one of the minority owners of the seller didn't want to sell. So we ended up having to do it as a statutory merger, which is very uncommon for these structures, for deals in this size. But it had to be done that way to just close things out and effectuate the transaction. This is really comes down to checking the cap table and the shareholder agreement or operating agreement, right? But it's really, you need to understand if there are going to be obstacles like minority holdouts. Because if it's not the sort of thing you want to find out about right before closing, right? If it's going to happen, you can get out in front of it. But some of those mechanisms take time, and so it's better to do it sooner rather than later.
James David, can I hop in here with a quick
Yeah.
question? Wouldn't that fall into the red flag bucket if sellers aren't aligned, or excuse me, equity holders in the business being sold aren't aligned? It's just you worry even if you can get the deal done, you worry about all these downstream possibilities of, I don't know, sabotage, bad will, who knows what.
Yeah, I would say more yellow flag than red. It depends on the nature of the business and what involvement you need from those individuals post closing, right? Because if these people were just silent investors, didn't have any role with the company, then all right, they're just disappointed at their returns. Whereas if you have somebody who's like a key operator who has equity in a business and is not on board with going forward, like that's a much bigger problem. So I'm not willing to generalize in a response, pulling a lawyer answer on you there.
Yeah. Well, and in terms of kind of gauging if a deal will be, it sounds like there's ways around it, but it depends. Hard to generalize, but like, should you, how do you as the searcher know when to push to see if a deal can still be done? If I learn as searcher that somebody on the cap table doesn't want it to happen, like how much money do I spend in diligence? How far do I push it to uncover whether or not I can get this thing done?
Yeah, I mean, you should be able to get the answers to these questions from the very sort of preliminary diligence, legal diligence, right? Because you're going to be looking at the seller's organizational documents, right? The shareholder agreement, the partnership agreement, operating agreement, whatever it happens to be. So that's going to be one of the first things you ask for.
Okay.
And so, right, this is the sort of thing that we're looking at, right? One of the first things we look at, because we know it can have a major impact on a deal structure. But it's often pretty easy to tell early on, at least to be able for us to have our client ask some follow-up questions.
Mm-hmm. Right. Great.
Something else is that in the case we talked about with that merger, the reason the person didn't want to sell is they saw a lot of upside, right? Now, obviously the main shareholders just wanted to get out. But it's not necessarily an indication that there's something wrong with the business if a seller doesn't want to sell. In fact, sometimes it's an indication that the minority sees upside that the others don't, and that's not necessarily a red flag. So,
great point.
So the second legal diligence thing is whether or not you have some contracts that you need to have as part of the business, and whether or not they can be assignable. So this will often happen if you have either government contracts or you might have large enterprises. I don't know if any of you have had the pleasure, or maybe I should say the displeasure, with being onboarded as a vendor at some of these large either companies, institutions, universities, but it's a long time. It takes a long time. So in order to avoid having to go through that entire process again, you often, want to see, can I assign the contract? If the answer is no, sometimes you have to be a stock deal. This is probably the main reason when we see it being stock deals. This is often one of the main drivers, is the desire not to do this. Because the other thing is, even if you assign it without consent, if they know that it's being changed around, if you have to tell them like, oh, hey, send it to this new bank account, that's often a time for them to flag and be like, oh, let me look at this contract we haven't really looked at for a couple of years. And, oh, I've decided to cancel, or renegotiate or something along those lines. So it's something you generally want to avoid, anything that would make your clients, suddenly scrutinize the relationship with the business.
And Bill, so government, big business, are there just kind of rules of thumb here about types of industries or context where this is going to be more likely to not, they're going to be not assignable, freely assignable?
Yeah, so we don't do that much work in the world of, for instance, healthcare providers, but we did do a sell-side engagement with one, and they had insurance companies that if you're getting paid via insurance, those contracts aren't assignable, because insurance companies are insurance companies. They always have the most insane contracts. And two, yeah, so basically, if you're being paid via insurance, healthcare insurance or other types, then that's usually something. The other thing I would say, yeah, government contracting can be its own separate thing, but you can see government contracts. We're dealing with media agencies that specialize in working with local government, so you can see this pop up in sort of all sorts of places. So
okay, thanks.
Yeah, so the next thing is, do third parties have any claims on the assets? So this often happens a little bit later in the diligence process, but often as part of your process, you'll do what's called a lien search, or you'll have a third party do a lien search. And what that means is they'll look up public records in, wherever the seller is located. It's usually in the specific jurisdiction. Sometimes it can be state, sometimes county, etc. And they'll show if somebody has a claim on the assets. It could be probably the most common is like a business line of credit that a seller has with its bank. But there could also be vendors that have claims, or even the SBA, right? If you're buying a business that was previously bought using SBA financing, there could be an outstanding SBA loan still on it. And what as part of the transaction, as part of closing, you need to get all those debts paid off, right? So what you'll end up doing is executing something called a payoff letter with those lenders. And it's a short formal document that's basically the lender saying, if I receive this amount of money on this date, then this debt is paid off in full. And it can be a little bit messy to coordinate all those, but it's one of those things that needs to happen, because if there's an outstanding claim, some kind of lien on the assets, then you don't own them free and clear right after the transaction. And obviously, you buy a business, you want to own all the assets of the business without any liens that somebody else put on them.
And James David, when we're talking about liens on assets, I assume that means almost always like physical assets or real estate. So in airball type complete, like you're just buying goodwill in the business, you're less likely to see liens, or is that not how what do you mean by assets necessarily?
Probably less likely, but if there is like a line of credit, like I mentioned, there often those liens will be on, there's specific wording. It's like all the assets of the business, including blah, 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 IP, and right there, they'll just attach a lien to everything. So is it less common? Sure, but it still happens.
Yeah.
So the next one is a question of whether the seller wants to exclude any assets from the deal. So common things when you're buying a business, if the founder has some personal property, so they might have some stuff in their office they want, their computers is a pretty common one to ask for. Sometimes they have a car that might be in the name of the company, but it's really their personal car, and so they'll want to exclude that from the asset list. Where this becomes especially tricky is if you're dealing with a carve-out situation, where you're buying a subset of the assets from an organization. In that case, you will often have very detailed descriptions of this, yes, this comes, yes, this doesn't come. With intellectual property, that can get a little bit tricky because sometimes the code is a little bit meshed. Usually this is a pretty straightforward process, and really the question is, is this used in the business? Is this essential, part of the operation of the business? And if the answer is yes, then that should be coming with the deal. So
the next issue is the financials, and the financials standing up to a little bit of scrutiny, right? You should always have a QLE prepared, do your financial diligence, especially on smaller businesses. Nobody has audited financials in these markets, or very few do. So, but one of the biggest issues that can happen in these smaller sizes is a business seller will be using cash-based accounting, and you'll need to use accrual accounting for your, loan calculations and modeling and valuation. And often that transition from cash to accrual-based accounting can cause wild fluctuations in, sort of normalized revenue numbers and potentially valuation. We've seen more than one deal blow up as a result of that transition. But you need to understand it, right? As the buyer, you need to understand how the business is going to operate going forward. And normally that's going to be on an accrual basis.
Mm-hmm.
So the next one is, does the seller have any registered IP? So intellectual property could be its own several part series, but essentially in most businesses, they will have either some type of mark, like think a trademark. And in businesses on the smaller side, it's really hit and miss as to whether or not they've registered that trademark or not. That doesn't necessarily mean that they can't go ahead and register, but we had a situation where we had a client who bought a business. They had an unregistered trademark. They didn't think it was going to be an issue. And then after closing, they registered the trademark. And then all of a sudden, people came out of the woodwork and said, hey, like that's a breach of ours, because when you file with the USPTO, the trademark office, you basically say, hey, here's my mark. And that opens you up to have other people come in and say, hey, wait a second, that's close to what we're doing. It is less common for there to be issues with patents. It does happen. And there the question is, how long does a patent go? Because patents expire, for instance. And do you have a way of looking for a system, I should say, for looking for people who are infringing on the patents and sending out cease and desist letters? Like how do you actually deal with that process? Copyright is things like copy that you might have on a website. If you have a website, the code involved in the website, you very rarely have that registered, but it is still very important to say, hey, anybody who's worked on code on the website, anybody who's provided content for the website, they need to sign an agreement saying that all of that product belongs to the company. Because the default in the United States is actually not that. The default in the United States for copyright is whoever writes it, like writes the code, owns the code. And you have to have a separate agreement to make it clear that no, that actually belongs to the company. So,
Guys, if I may, a couple of follow-ups here. So on the point you just made there, Bill, about code on a website. So wait, so so many people will have hired, the website will be done by some Upwork contractor 12 years ago, and they never got any, I forget the phrasing, but any document saying that giving the rights over to the business owner. So So yeah, how to deal with that.
How to deal with that. So a couple things. So first of all, if you're using a platform like Upwork, usually the standard forms that they use are going to have that language anyway. So you're usually going to be covered if you're going through them. Where people often get in trouble is when they're bringing on an independent developer, but they're not using one of those platforms, and then they don't do it. And the way to solve that is, are you still in contact with them? Because if you are, you can usually just go to them and say, hey, could you sign this thing? And they're usually more than happy to do that. Alternatively, sometimes if like you haven't had contact with them and they developed a website for you like 5 years ago, a lot of times it's just a risk that you just accept, because like the probability that some guy's going to come out of the woodwork and say, aha, I own this, code for this website, it's pretty low.
Yeah.
It's higher, by the way, if you're like, if it's just like website that's essentially a billboard for your business, fine. If you're developing an app that the actual technology has, utility value, then you have to be a lot more careful about making sure you own all of that code, and you go through, look whether they used any open source libraries and all of that jazz. So
that's probably its own due diligence step in cases like those, tech due diligence, essentially.
Yeah, there are tools you use to comb through code and come up with open source libraries. There are different licenses. Some license like MIT is a great one, Apache's fine, and there's other open source licenses that aren't good. And so anyway, that gets a little bit technical, and if you want to geek out about it, I'll keep talking about it. But yeah, it can actually be a real pain. Sometimes it can take hours just to go through and go through that process, but mostly it's the tech folks that end up having to do that.
But going back to the website example where, an Upwork contractor did some thing on the web for the business you're acquiring. I guess the other question to yourself would be along the lines of just take the risk, is like, if this person did surface, the original Upwork contractor did resurface and say, hey, that's my work or something, and it weren't covered, that you didn't have the seller of the business didn't have some sort of coverage already. The question to ask yourself as buyer is like the replaceability of the thing. Because then it's like, if you just worst comes to worse, and the developer who did the website isn't covered and wants to charge you $10,000 to give you the rights to the website or whatever, it's just like, okay, well, I could also just I could just walk from that website and redo it, sort of thing. Is part of the calculus.
Exactly. And we sometimes have this as a fundamental rep. So it's not uncommon that if that does become an issue and there's like a pretty concrete, like $10,000, then, you can work something out with the seller to pay for that or whatever. So it's a manageable issue. Most often, very most often.
Great. Thank you.
Next issue that can come up, real estate. So there's sort of two scenarios. Like, one is where there's sort of a commercial landlord, and the other is where the seller is the landlord. There's also some environmental reports on here, but I'm not going to focus on that. So if the landlord is a third party, right, that landlord is going to need to assign the lease, or you enter into a new lease. You would think that most of the landlords would be reasonable and that they would be happy to have a new tenant signing up for a long-term lease, and that's not always true. We had one transaction. It was for a laundromat in, I believe, New Jersey, and everything was finalized. The docs were in order. The loan was ready. Everything was ready to disperse. Everything was good. The landlord refused to assign the lease, and the deal died at the very end. So hard to have foreseen that was going to be the final outcome, but right, I've seen it. So, maybe something to get out in front of and talk to that landlord sooner rather than later. If the seller owns the real estate and is going to keep the real estate after the transaction, then you're going to need to calculate a market rate lease, right, which sort of involves looking at some comparables and that sort of thing. But oftentimes, as a buyer of the business, you're going to really want to right of first refusal should the seller decide to sell that real estate, that you have first option, because otherwise you could end up in a world of hurt with a business, right, that can no longer use its physical location, which is not a situation that anybody wants to be in.
The other thing I'll just say about that as well is sometimes if it's just a generic office building, it's very replaceable. There are some businesses we've come across where it's like, this is a particular type of business. This is the only location that's zoned for this business in this town. And that is actually much more of an issue. If it's like, oh, we have generic office space and you could literally move, kind of to your earlier point, Will, what's the replaceability? And if the replaceability is pretty easy, then you don't have to stress. But if it actually is difficult to find a new place, like if you're buying a manufacturing plant, you can't just go down the road and be like, there's a dozen factories here that equally work well. So.
And is there any generalizability around whether it's good or bad if your seller wants to retain the real estate? I guess it's probably hard to generalize, like you just said, Bill. Like if it's so mission critical, it's a risk factor hanging out there, and you probably want to buy that real estate.
Yeah, I would say yes. If it's mission critical, that can be real tension, especially if you're talking about like major plant and equipment on the location. The other, I think that's basically it. And the question that you can ask yourself is, in the operations of the business, how important is it, that physical presence? Like if you're doing stuff at the site, if it's office, whatever, but if you're actually repairing things, building things, like something that's site specific, that's going to be expensive to move. So, it's an issue.
Just to throw my own kind of anecdotal observations here from my guests, I feel like it ends up being roughly 50-50 that a seller will want to hold on to their real estate as opposed to sell the real estate with the business. And so I feel like it's pretty hard to generalize as well. And you'll hear some guests also, their interpretation of that can be, I've heard more than one guest say it didn't bother them. They didn't feel exposed that the seller wanted to retain the real estate because they felt like it was one more hook to keep the seller invested in their success, because now the seller's their tenant. You want your tenants to be successful businesses. So it's going to keep the seller invested in your success, sort of logic. Not sure how true or not that is. But I don't know. I feel like this was a hard one to generalize because I see a lot. I don't feel like I see a pattern so much.
One other thing I'll just jump in and say, a very common deal structure we're seeing, especially on the independent sponsor size deal, is a sale leaseback, where the property, if it is owned by the seller, the seller might be selling the property, but not to you, but to a REIT that comes in and buys this and then leases it to you for the business. And a lot of times you can get higher valuations that way. That can be a way to, because the seller might be thinking to themselves, hey, what I care about is selling the whole package, my property and my business. If you can bring in a REIT that's willing to pay a fairly high amount for the property, then, that gives you room in terms of paying less comparably for the business. And so I just throw that out there. We've seen that deal structure prop up a lot of times on slightly larger deals, but still.
Mm-hmm. And just to emphasize something you said too, Bill, about the right of first refusal, maybe that's standard. Yeah, but I remember hearing it from my guests. So just to make sure the audience hears that, if the seller is going to retain the real estate, it seems like best practice that you, buyer, have right of first refusal so that they can't sell it out from under you.
Yeah. All right, so the next one is, are there any permits or licenses needed to operate the business? And this can be a tricky one. We've seen people run the gambit from getting their own electrician's license in order to be able to run this electrician's business, to people that have no intention of operating of having any sort of license and want to buy into a licensed business. Now, some businesses you literally can't do that. If you don't have the license, you cannot run that business. Other times you can, but it can be tricky, because if a very common thing to happen is you have to have some type of master license, somebody at the company has to hold it. Well, if it's not you, then whoever holds it kind of has you hostage. And if you want to easily replace them, or if they just decide to, they die, heaven forbid or something, you got to run out and find somebody that can do that. So that's a real risk that you need to know about as part of the business.
So the next thing you want to know is, are you buying into a lawsuit, right? And I'll say, right, it's a little hard to generalize because there are lawsuits and then there are lawsuits. There could be somebody who's just filed a strike suit against the seller over some kind of nonsense, or there could be a lawsuit going on between, there could be like major employee, right? You could have an employee suing for discrimination claims, or you could have lawsuits between the sellers themselves fighting over control of the company. We have another one right now where somebody's dealing with some patent prosecution, right? And the buyer is willing to accept, willing to take that on. So hard to generalize here, right? Obviously, better if there's no outstanding litigation or no threatened litigation, but if there is, you need to know about it and then sort of evaluate the prospects, what kind of lawsuit it is, prospects of success, what it means going forward, does it carry over to you, et cetera. And you have to have the information to do that analysis. So get that information sooner rather than later.
Next one is the seller on good terms with employees? I mean, we've kind of talked about this at each stage of our office hours, LOI, major sticking points, and it comes up again because it's such a critical issue here. Here it's questions like, what are the contractual relationships like? Does that match with what you're doing? If you've got a sales guy on commission, is he's going to continue to be on commission? Is he happy with his role there? Do you have other key people? Sometimes we've been in situations where the employees are unionized. And you have to deal with a collective bargaining agreement and figure out how you're going to deal with that. So for small scale manufacturing, sometimes other things you can see those type of issues arise. But this is a sort of issue where a lot of times it comes down to meeting the people, shaking their hands, getting a sense of what their view for their own future is. And that's something that frankly can be a little bit of a dance with sellers, because the deal here is always, when can you talk about it? And that always varies. It's often a sensitive point. So
next is tax liabilities, right? As the text says, even in an asset sale, certain tax liabilities carry forward. So normally you want sort of tax clearance letters, which are official documents from states, counties, cities, if it's applicable, just any sort of taxing authority, and it can be multiple taxing authorities at the same level of government even. And what you want is just confirmation from those entities that the seller doesn't owe them any taxes, and so there's nothing going to affect you going forward. One of the major ones that sort of sticks with a business is sales tax. So if you are buying an e-commerce business or a business with an e-commerce component, right, sales tax compliance has evolved a great deal in the last 5 or 6 years since the Wayfair decision by the Supreme Court. So that can be an absolute mess. There's software that helps with it, helps with compliance now, but there's different thresholds in different states and nexus requirements. It can be an absolute mess. And there are a lot of sellers who have taken very aggressive tax positions relative to sales tax in e-commerce. It's becoming a little more normal for everybody to try to be more compliant, but you still have plenty of cowboys. So just be aware that is a possibility. And And it's a possibility in certain businesses more than others.
And the last point we're going to talk here is the right insurance in place? And so oftentimes businesses will have insurance. Sometimes it's just general liability insurance, but you'd be surprised. This can actually become a major deal point. We had a transaction where the buyer was coming from out of state and was buying or looking to buy this local business. The seller was a local, and he went to the insurer, the same insurer where the seller was being insured, and basically the broker said, "I like the seller, I don't like you. If you come in, you're not going to get her rates. You're going to get substantially higher rates." And that materially changed the value proposition for the business because he had a much higher increased cost. And so don't necessarily take for granted. I mean, most of the time this is a non-issue, but it can be an issue, especially if you're dealing with a type of business where they need to have insurance. So
Guys, and on insurance, I mean, one of the Acquiring Minds sponsors is an insurance company. Do you bring in a vendor to do an insurance diligence for you? I mean, that's one thing that Oberle, the sponsor, offers. Is that a way to approach this?
yeah, you can bring in a third party to do some diligence. You can also sometimes talk to whatever broker the seller has used to get their insurance in the first place. You might not get the best rates that way if the broker isn't great, but that's a common way to do it. But yeah, if you have a third party vendor that is willing to do it, that's best practice.
All right, so that is the end of this presentation. Thank you for listening. We, as Will said in the intro, right, we do M&A almost exclusively, right? And sort of one of our unique value propositions is that we do almost all of our transactions on a flat fee basis. So when you work with us, you know what your cost will be before you ever start. So we offer pricing certainty, and our payment terms are also designed to be aligned with searcher and sponsor mechanics, right? We understand what searchers and sponsors are going through, and we do what we can to work within the constraints that you're facing. So thank you.
Great, guys. Fantastic presentation as always. Let me just put both of your LinkedIns into the chat so everyone can connect with you. That's James David's, everyone. Connect with James David on LinkedIn. And here is Bill's. So find the guys on LinkedIn as well as going to their website. Okay, let's get to questions. We've had a bunch come in and then more now. Okay, let's do stock purchases. What can you do in a stock purchase to avoid assuming any unknown legal issues that may come up later? Of course, the big risk of doing a stock purchase. How do you mitigate?
So there are a couple of different approaches you can take. One thing you're obviously going to have is an indemnification from the seller for anything that arose pre-closing. And those indemnifications tend to be more robust in a stock purchase agreement for all of those reasons. A couple things that you should just sort of keep in mind is that just because you have an indemnification does not necessarily mean that you have the cash in hand, i.e. the seller can just sit there and be like, well, sorry, I can't pay you. So that's why, one, it's fairly common to have an offset against the seller note. Two, sometimes, especially if you know that there's a litigation outstanding, you'll put some money away in an escrow. So we've dealt with a situation where there was a large litigation outstanding, and the negotiation was, we're going to put a certain amount into an escrow account until that's settled. And that was a stock purchase agreement. So that's a little extreme. Most of the time, sellers are not going to go for that. But if you do know that there's an outstanding issue, that's one way to deal with it.
Great. Back to taxes. underpayment of sales tax. James David, a couple things there. Cowboy, I heard you use the phrase. So and probably, and you also, so two parts here. What to do if you're dealing with a seller who's a cowboy who has been, let's say, not dotting his I's and crossing his T's with respect to sales tax, how to handle that. And then you also mentioned particular industries where it's more or less common. We'll assume e-commerce is where it's particularly common, but weigh in on the industries. First, how to handle it if you're dealing with a cowboy seller.
Yeah, I mean, first, it is most common in e-commerce, right?
Okay.
Because if you're selling in a physical location, it's just right. It's also easier if you're doing a physical location because you know that sales tax applies in that state because you're physically there. What can happen? Often you'll have special indemnifications provisions just for the tax element. That's just some of the stuff Bill talked about. So even if it's an asset deal, you can have a special indemnification for tax. For sales tax. It's also possible, I mean, oftentimes you can get a rough sense of whether they've met certain nexuses, right? You're going to have, if it is an e-commerce deal, you're going to have the raw transaction level data. So in many ways, with some of these software tools, you can kind of reconstruct it to get a sense of what the real exposure is. And often if this more and more, if this is an issue, it's because somebody just barely tripped over a threshold, right? There's bigger sellers, bigger e-commerce sellers. Like this is not they do it now, right? In terms of sales tax compliance. So this is more common for sort of smaller sellers, in which case they might have only tripped over it in one state or two states. And then you can sort of carve out the data for those states and get a sense of what the exposure is. Then you can, I mean, sometimes you could force them to pay it, right? You force them to go back and pay it, or you can just pay going forward and right build in some sort of way to shift some of the risk about them coming, about that tax authority coming and trying to collect.
Mm-hmm.
But you in the e-commerce setting, you have the data usually, so the right providers can parse it for you.
And this idea of tripping the threshold, point being the authorities only care about businesses of a certain size, revenues of a certain size.
It's actually, it's not that. I mean, it is in a practical sense, but in a legal sense, you have to meet a certain either volume of number of transactions or dollar amount of transactions. It varies based on the jurisdiction. It is a patchwork, right? Sales tax compliance is a mess. Every state is different, and they're constantly changing. But there are actually thresholds for the sales tax to even apply at all.
Okay.
And it only applies in certain platforms, right? If somebody's selling through Amazon, this is not an issue, right? Because Amazon collects, right? If you're selling through one of the marketplaces, so this only applies to like somebody's got a Shopify store. But that's whatever. We can go way too deep in those weeds. And I know that's not what most of this audience is looking for. So.
Well, let me ask you about one particular other industry that's common with searchers, of course, home services, where the customer's paying in the moment. I assume because most home services companies are all home services companies are geographically confined. They benefit from the same kind of cleanness as a retail location, where if I buy the HVAC business in Virginia, I just got to worry about Virginia. I can quickly see if they've been collecting sales tax, pretty straightforward.
And there's also some distinctions between goods and services too, but so like no sales tax on our invoices, for example, as attorneys, right?
Yeah.
But yes, they would be local, and so it would be much easier to tell.
Super. Okay. Let's see here. Got a lot to choose from here. Sorry, everyone. Would you guys expand on contract assigning? Is the main idea of, let's say, a long-term vendor contract being renegotiated or put out for new bid prior to expiration. Oh, shoot, sorry. I thought I'm not sure I understand the question. Being renegotiated or put out for bid prior to expiration. I think they're asking about, Bill, your point of if the you said how, like, if you seek assignability, a contract needs to be assigned, it calls attention to the relationship. And so maybe it was kind of, they were just kind of happily sending invoices and getting paid, and the customer wasn't thinking much about it. But if you force them to assign the contract, then they have to think about it, then they might. Can you say more about that? I think that's what the questioner is getting at.
Yeah, and so I think a couple things to think about. Number one is especially if you're dealing with large organizations, you never want to raise a flag and say, hey, look at me. Because a lot of times the value in those is that they just keep on sending it to you, and they might have started with having a personal relationship, and you just don't want to disrupt that at all. Generally speaking, if you have suppliers that you've worked with, usually they're happy to continue to supplying with you at the same rates, but you never know. You can have some key things even on that side. The other thing I say, and I think they kind of were hinting at this sort of project-based stuff, right? If you have a company that does, large construction projects and has like lots of stuff outstanding, how do you potentially deal with that? That a lot of times is, if it really is that a lot of the value of the business are these big projects, then a lot of times you might want to have a conversation with the people on the other end of it. And it also depends on how valuable the contract is versus how valuable the relationship is. And because a lot of times they'll have contracts, but realistically, what you're worried about is the relationship. So you just have to be sensitive to that as well.
Yeah. This stuff is very delicate and case by case. It's not unlike the seller's relationship with his or her employees and how every case is going to be different. But I'm reminded of a guest who bought his business, didn't want to announce the sale of the business to all the customers, just wanted to kind of seamlessly, quietly have a transition over. And he'd get to it after, he'd tell all the customers later, after the transition was locked down, everything was fine. So he waited 6 or so months, and then it was weird that he went back to all the customers and was like, hey, I'm the new owner, because the customers were kind of like, well, why didn't you tell me sooner? Mm-hmm. So only point here is that it's delicate, and there's probably not a best practice here. You got to feel out each business and its relationship with its customers.
Usually what you want to do, if there really is a relationship business, you want the seller who has that relationship to be warmly introducing you after the closing, right? And being like, hey, here's this guy, he's bought this business, I'm vouching for him. The times where you don't necessarily want to announce at all is a situation where, again, you're dealing with some type of faceless organization. And so, them doing that is not going to help the relationship, but, you raising the flag is going to flag something that, somebody in that is going to be like, oh, I guess now it's time to reevaluate. So, how does that relationship work? If there is that relationship, have the seller who has that relationship introduce you, usually pretty soon after closing, vouch for you. That's usually the best way to do it.
Mm-hmm. Great. On the trademark point, you buy the business and you find out that it's not trademarked, and then you try to trademark it, and then there's all these other businesses out there with the mark already, and so that's a problem. What to do then if you do learn that a business hasn't your target has not trademarked its name, and you run a trademark check and there's all these conflicts? How do you deal with that?
I think the real question is, how much value is there really in the brand itself? That is very dependent on the business. If there's a lot of value in the brand and there's a lot of potential people that you're infringing on, then it's a problem, right? I think a lot of people tend to overestimate the value of brands, especially when they're just starting out. Because a lot of times it's actually value that's attributed more towards a person, a personality, a relationship, whatever. But that I would think would be the first step. And then, you know, because you don't want to be in a situation, I mean, heaven forbid, the worst case scenario, right, is when they're like people are buying the product because they're actually are getting it confused with you know, a different product, you know, and you do have serious risk that you're going to have to shut down something that will decrease your sales materially. You know, that's an actual operation risk.
But there is, even if the mark is unregistered, right? And somebody does come in and register it later, right? If that mark was already in use, there is something called prior use exception, effectively, right? So just because a trademark is not registered does not mean that it is not valid.
And the other thing I say is what you can do is you can have an attorney who specializes in IP to effectively say, hey, go through your process of as if you were going to register this mark. Let me know if there's anything, like if you were registering this for the first time, are there any red flags that you would give me? And if the answer is, I mean, there's always going to be the chance of something, but nothing major comes up, then like, you know, usually that's less sensitive.
Just for my own case, registering the acquiring minds mark, yeah, it was a two-step process where the attorney ran a search first and came back with kind of a grade of certainty that I would get the mark. And then step two was actually registering for the mark. And so that first step is what you can do kind of as a first step.
Yeah, exactly.
Should I set up a separate LLC just for my search? And then when I buy a business, will I need to set up a new LLC when the deal closes for the business to sit in?
Yeah, I mean, you don't have to have your LLC filed before you start your search. If that's what's holding you up, go ahead, right? Create it, right? Create your single member LLC, right? Don't let that be the step that sort of blocks you in your process. It probably does make things a little bit easier from an accounting perspective, right? To run the expenses of the search through an LLC. But that's just to make your taxes easier at the end of the year, right? You don't need it. And if you do create a search LLC, you know, then that probably is the entity that will buy the business, right? So, and you know, if you're concerned about what name it should have, don't be. Just pick something that works, right? Get your LLC and move on with your process, right? Don't let that be the thing that holds you up. There's plenty of services online. You can do this yourself, a couple $100 in state filings, and you know, just check that off the list like this afternoon if that's what's holding you up.
Related to that question is one you've heard the debate about what to call yourself as a searcher. Do you call yourself the name, the fancy, lofty name that you've given your LLC? In other words, do you position yourself as private equity, or do you just go by your own personal name? And that's kind of a strategic question that probably depends on your targets and how you want to present. And it's very case by case.
Yes,
do I want to be Will as I go out into the world asking to meet with sellers, or do I want to be Evergreen Industries going out into the world?
But also, like if you have and I've seen a lot of websites that searchers and sponsors have, and you know, I've looked at enough of them, right? Your buyer's going to look you up, and they're going to tell, right? So again, it's not the most important thing, right? It's more important, especially if you're buying, you know, sort of a legacy business that somebody's had for a long time. I would probably lean towards being yourself, because it's the rapport with the seller that's going to help you win the deal, right? And if you're dealing with a little bit larger, then maybe it does make sense to come across as an entity. But I've seen plenty of people who sort of do that, and it's really just an empty suit behind that. So but if you are in the smaller space and dealing with, you know, somebody who's part of this so-called silver tsunami, whatever. I would encourage you actually to be personal, be yourself.
Yeah. What about does this, the ability to take all of your deal costs, which can get into the tens and thousands of dollars, and have those become part of the deal? The cleanliness of doing that, does that hinge on whether or not you've been personally paying for these deal costs versus your LLC paying for these deal costs?
Um, I mean, it's cleaner to do it through the LLC, but again, no.
Not that. Okay. Okay.
Right, because it's a single member LLC, right? If you're doing a self-funded search, so that's a disregarded entity anyway for tax purposes, right? It can get a little more complicated if you add complexity to it, but in the simplest form, no.
Somebody asks what the solar tsunami is. They misheard you say,
Oh,
somebody say
yeah,
the silver
silver
tsunami.
silver tsunami. That's what a lot of people. I don't really love the term myself because I've got a little patch of gray hair back here already, but um, the term means a lot of people in their 60s and 70s who are going to be retiring in the next decade or so, 5 years, 10 years, whatever, however you want to parse that. And so that a lot of these people are business owners and are looking to sell those businesses. So that's what that term refers to.
The giant kind of mega trend that is driving search.
The trend that helps make a lot of this possible. Yes.
Yeah. Yeah. Personal guarantees. So are there any legal strategies to avoid having to put my house down as collateral for an SBA loan?
Live in Florida.
Okay. Putting it in a trust, taking my name off the title. This is a somebody who's saying it's been a sticking point with their partner. So yeah.
At first, I'll speak to the Florida thing that I mentioned. That Florida has a homestead exemption in their state constitution, I think, is why I said that. I mean, there can be certain things you can do, and some of this depends on the lenders, right? We did have one that we did for someone in New York where the bank decided not to fight the condominium association, and so didn't bother.
I love those condo associations.
I don't think
actually doing some good for you.
Yeah.
I don't think that's a common scenario, but it did happen. I mean, there are things you can do, but it's going to depend on the lender, and a lot of times there can be look back requirements or look back periods that affect some of this. So it may be that you can do some of these mechanics, but then have to wait 6 months before they would basically take effect for purposes of shielding assets.
Well, you guys, of course, question that often comes up in this space, but typically when I'm doing a panel or an interview with somebody who's on the lending side, how do I get around doing a personal guarantee if I'm doing an SBA, I'm in the States doing an SBA loan, and often the lender response is essentially, you can't. So, they usually soften that, but they're basically saying, really don't try. I mean, that's really structurally part of this whole loan product by the government. Is your response the same or what?
Yeah, I'm not going to contradict the lenders, right? I mean, there may be certain things you can do. We talk to people who try to do certain mechanics, but oftentimes we just sort of say, like, this is just how this works.
Yeah. And the one thing you shouldn't be doing is we've had to say this on several sessions, but do not be committing fraud against the government. That is a bad idea, and we do not recommend it.
Yeah. Yeah. Okay. Great, guys. Going back to the topic on lawsuits, are you buying a lawsuit? And James David, the way you characterized it was like there's small lawsuits and big lawsuits, and small lawsuits are obviously, are often manageable, and big lawsuits are not. Is there a bright red line there? Is there some way that a lay person can kind of understand what's a major lawsuit versus minor?
I'm not sure. 'Cause
Or is it pretty self-evident? Like if you come across that, is it going to be
Not-
pretty clear even to a layperson?
Not necessarily, because certain claims could be horrendous,
Mm.
even if they're small. But certain things, right? If there was a claim for, say, unfair trade practices, right, that could slam you for triple damages plus a whole bunch of other consequences. So even if the dollar amount was small, if you lose that, like that's a big deal.
Mhm.
I mean, anything that is looking to affect the transaction itself, obviously, right? Because somebody, like if the owners or the seller are fighting, right, one of them may file an injunction to try to stop the sale itself. So, right, that's a problem. I mean, many times lenders are going to be, right, the lender will take it out of your hands as to whether something is big or small, because SBA lenders, a lot of times, like if there's, right, banks don't like litigation or litigation risk. So we've seen more than one where that was kind of the bright line, is like the bank won't finance it until this gets done. But if there's, like if it's a construction business, some kind of contracting business, right, you're going to have small claims floating out there with subcontractors or whatever, right? It's just part of the business. So that's not a big deal. But if it's, you got an employee suing the company for sexual harassment, right? Different story. So, I mean, you can't really generalize even based on dollar amounts necessarily, but obviously the more dollars, the more likely it is to be existential. But yeah, no, you're gonna have to really just talk to somebody who can help you parse those things. And it, like when we do it, like we'll read complaints and replies, and I'll read the filings. I did litigation for a few years before I transitioned to M&A work, so I can sort of give people a pretty good sense. But Bill, I mean, a lot of times you don't even feel comfortable doing that. So
No, I will always give it to James David because he has that background, and even as a corporate lawyer, as a non-litigator, it's often difficult for me to go through that analysis without consulting somebody with real experience.
Great. Okay. Well, that's a very clear answer. So if there is any litigation, basically engage attorneys to help you suss it out and how serious it is or not.
Yeah.
Yeah. Great. When this, and everybody, we are 3 minutes past the hour, so we're going to start wrapping up here. Just a couple more questions. If you have a burning question, now would be the time. When the seller is keeping real property that the business operates in, and didn't previously pay themselves from the business for rent, so the payment amount is TBD in the LOI. How do you protect against the seller not paying the mortgage taxes, et cetera?
So, I think this is interesting because this is essentially the idea of what happens if the seller defaults. I would have to know a little bit more, but I believe what happens is that the lease continues to be. This is probably local real estate law, so saying something that is generalizable might not work. But in general, for instance, if the seller were to sell their property, then that property would still be, subject to the lease, essentially. And so I would have to look under local laws as to what happens if there's a default. Frankly, it's usually pretty rare for a seller that has just received a real nice chunk of change and is getting enough money from the lease to be defaulting on their mortgage for that. But I suppose it's possible.
Great. Non-competes, these come up a lot. The question is, how enforceable is a non-compete term for 3 years in the NDA to not buy in the same industry?
So right, non-competes depend on what state you're in. 3 years is going to be reasonable pretty much anywhere. The question is, right, as we talked about in a prior presentation, right, with non-competes, it's duration, geographic scope, and right, sort of definitional scope, right? How much of the business activity are we covering? How much of an area, and how long? So as long as it's reasonable, and that means that judges decide, right? So, right, there's case law, but it can vary. You can get different outcomes. But that's going to be fine to, right? If somebody has a business that operates in one particular metropolitan area, right, you're not going to be able to stop them from starting something or buying something in another city. But it could be that the business operates in, a 3-state area, in which case all 3 states can be covered. Right? Sometimes it could be the whole country. It just depends on the nature of the business.
And as always, we just want to reemphasize this applies to non-competes with the seller. Same rules do not apply if you're trying to bind employees to non-competes.
Although that currently is in active litigation, right? A federal judge in Texas has enjoined the FCC rule as of the date of this recording. So that is still being litigated actively.
And if you have a nice, clean non-compete, reasonable a judge would smile on the non-compete, say it's reasonable, and your seller, not employee, but your seller then competes with you, and just in clear, flagrant violation of the non-compete. Is it one of these where you actually would pursue it, or like so many things, the non-compete is there to deter somebody, but if they just flout it, it's not really worth your time to go after them anyway?
It depends, again, how much size, and often the non-compete is in conjunction with a non-solicit, which the non-solicit, which is not subject to all this litigation that's going on right now, but separate question, separate issue there. But like if this person is trying to steal your customers, that's a different story than they're just trying to start from zero again.
Yeah.
Right. So it really is like, how much does it affect your business? And then how much do you want to fight? Some people just like to fight, in which case go for it. But you have to evaluate, like, what's the actual effect on my business? Is it worth my time, effort, frustration to do this? And it's hard to generalize there.
Okay. 2 more questions and then we'll wrap up. Unions, you mentioned unions. Any generalizable thoughts on unions? I've had guests who bought union businesses. It's been great. I've had others where not so great. So is it how do you guys react?
So what we think is usually the best approach is to get a sense, especially if you trust the seller, to get a sense of what the relationship with their union is like. Because there's some sellers for whom the union representative comes in once a year, they have a chat, they agree on whatever the increase of the pay is going to be, and that's essentially what that is. That sounds reasonable and fine, and hasn't been a problem in the past. You might want to do some independent research, but a lot of times it really does come down to that type of relationship. And there's always going to be a risk, right? That the relationship doesn't carry over, or that, there's a new sheriff in town from the union's perspective and they try to be hyper aggressive. That is one of the risks of the business. But I would say if the generalizable rule is have conversations about what that relationship has been like in the past, and usually it tends to follow the same pattern.
So it's not a flag necessarily. I mean, it's something that definitely needs attention, but it's not.
Yeah, it can be a very simple thing, right? And it just like, all right, here's the old contract, here's the new contract, we're changing some names. Right. That's the ideal scenario with employees too, a lot of times, but with the union contract, right? But if you're in a situation where they've been to arbitration, or there's been all these disputes, or you've had to get labor relations boards involved, like, okay, that may be a bigger issue.
Mhm. Okay, guys, final question. This has probably been touched on maybe a little bit here today in previous office hours. Are there any common issues you've run across that could be relatively easy to identify pre-LOI? So something that searchers can do before the LOI from a legal perspective that so they don't, to save themselves some time. Early filters.
So before the LOI, you're really just relying on whatever materials the seller is giving you. And so the seller, if they're being at all reasonable, should be disclosing if one of these things tends to be big. I'm thinking especially about if they have a problem with the founder or, that sort of thing. I would say that if you are looking at customer contracts, that's probably the easiest one because you should get a sense even from the sim who they're doing business with. And that you're gonna be able to tell that is gonna be a potential issue. The other thing I would just mention is most of the time legal comes in after financial due diligence, but there is one little caveat, which is the first thing legal does after signing an LOI is sending out that legal due diligence, because if there is a gating item, that should be taken care of before you start incurring other expenses. So do make sure that your seller actually responds to that legal due diligence the same way they respond to the financial due diligence, because you don't want to have the situation that we were talking about where the 11th hour something comes up.
Yeah, I mean, it would be if there are certain regulated industries, right, license requirements, that sort of thing, you would be able to tell right from the listing. You may not be able to tell, who owns, right, who holds the licenses, but you would at least get the sense of, am I qualified to buy this business? Right? Because if you're in one of those states like California that requires you as the owner to be the license holder for several different kinds of businesses, well, then right, if you don't have that license, you can't do this. And so that one's not for you. But short of something like that, from most sort of brokerage listings and sims, no, it's hard to tell, right? Right, even some of these gating issues from a legal perspective, you have to do a little bit more diligence. You get a little bit more information first.
And Bill, the sequencing that you touched on there, get the business under LOI, then kick off both legal and Q of E same time, and stay on top of the seller to make sure they're getting answers to you on both.
Yeah.
Just because if there's a red flag or a gating issue on either, you need to know ASAP because you're spending money, basically. Clock's ticking.
Exactly. And I would just say, because financial diligence tends to take all of the attention at the beginning, it's easy to let legal diligence questions slip. But do keep them honest on that, because if they're just focused on financial diligence, they don't respond to any legal questions, that will be fine as long as there's no legal issues. If there is a legal issue, then, as one of the examples, one person, they went through all this QOE and then they realized that the contracts weren't assignable. And then they realized that they didn't want to do that business. Well, they wouldn't have had to go through all that cost for the QOE if we were sell side on that deal. But if the buyer had just been on top of asking the right questions from their buyer diligence, then they wouldn't have incurred all that expense.
Yeah.
So,
yeah, it's good. It's a great lesson or story there. Fantastic, guys. Everyone listening, don't forget to check the chat there. Barlow and Williams, you can click through to their website and connect with Bill and James David. There are their LinkedIns. This will go out via email, this recording, in the next few days. We will do another one of these office hours next month. So be watching for that. You'll hear it on Acquiring Minds, see it on LinkedIn, also on the website. You can always see our upcoming webinars on the Acquiring Minds website, acquiringminds.co. And anything to add, guys? Are we good to go here? Right. James, David, Bill, thank you guys again for an awesome presentation as always, and we'll see you next month. This concludes the webinar.
Yeah.